Hi, and welcome to another episode of Coffee with Alissa. Today we'll be discussing estate planning basics, and to do so, I'll be interviewing Laura DelFratte, attorney, CPA, and a director in the Estates and Trust team at Schneider Downs. Laura started her career at Schneider Downs as a business valuation intern and maintains that accreditation in business valuation. In addition to a decade of experience at Schneider Downs, she's also worked at a large Pittsburgh law firm and a national accounting firm. Laura focuses her law practice on estate planning and administration. Her tax practice is specialized in the areas of estate, gift, and fiduciary income taxation. Laura and her husband, Mark, keep very busy trying to keep up with their combined 6 children. So Laura, thank you for taking the time. I know you're busy, but I really appreciate you jumping on here with me to answer some commonly asked questions about estate planning. How are you?
I'm great. Yeah, I'm great. Thanks for having me.
Yeah. Well, we'll jump into the first question. I think to start it out, many people think that they don't need an estate plan, or they're just apprehensive about starting the process because it kind of involves, thinking about death or bad things happening in life. But it's really important, we know, to have those documents lined up early in life so we can preserve assets, reduce unnecessary taxes and expenses, and really ensure that the people that you want to receive your assets, should something happen to you, actually receive them in the best way possible. Mm-hmm. So on top of that, these documents, they help you manage assets in the event of disability or incapacitation too, and protect privacy. So a whole slew of benefits that really speak to the importance of them. So can you start us off by telling us what are the common estate documents and give a brief overview of each?
Thanks, Alissa. Yes, I couldn't agree with you anymore. It is very important to have an estate plan for all of the reasons you said. You need it to have asset protection. You need it to sometimes save estate taxes and costs. And most importantly, you need it to reduce the stress on your loved ones in the time when they need it the least. So it's a great idea to start at the beginning and just go over some of the basic estate planning documents that you do need to have in place. The first one I want to talk about are powers of attorney. And those are documents that you use during your lifetime. And if you have a power of attorney, then you name an agent. And your agent's the person that can act on your behalf. There's 2 kinds that we typically suggest. The first is a financial power of attorney, and the other is a healthcare power of attorney. Now, your financial power of attorney, you name someone who can act on your behalf for all legal matters. So paying your bills, paying your taxes, filing tax returns, entering contracts. Your financial power of attorney can handle any of those situations in the event you can't do so for yourself. And this could come up if you were incapacitated, if you were in an accident of some sort, or even if you had some kind of logistical problem, such as you were out of the country. The other kind of power of attorney, your medical power of attorney, that's where you name someone who can act on your behalf and advocate for you for your healthcare decisions. You name somebody, and that's the person that the doctors are going to turn to whenever a healthcare decision needs to be made. Now, with your medical power of attorney, you generally also prepare a living will. And that living will, it's going to give your agent the instructions they need to make the decisions. So your living will usually sets out exactly what kind of healthcare decisions and healthcare you want in the event you can't advocate for yourself. So situations where if you are in a permanent unconscious state, you're in a vegetative state, you want your healthcare agent to know how you would like things handled, because you don't want one person to have to decide that for you or create a situation where there's a family conflict or any kind of controversy. So it's helpful to have both a medical power of attorney and a living will so that your family members know how you want to be handled, your healthcare decisions handled in the event you can't do so for yourself. So powers of attorney are effective when you're alive, but when you pass, your will is going to let the world know what you want to do with your stuff at that point. So similar to agents under their power of attorney, you're going to name an executor, and that's the person that's going to be responsible for carrying out all your wishes. And you'll name all of those wishes. You'll define those in your will. There's a lot more planning that can be done, but those are just some of the basic, most critical documents.
I appreciate that. That's a lot of great information. So a term that commonly comes up in estate planning is probate, and it can be, more complicated in some states versus others. So another good reason to have a sound estate plan. Can you tell the audience what is probate?
Sure. And you're right, Alissa. A good estate plan, they can eliminate the need for probate. And probate, it's different in every state, but it's the court supervised process that assets have to go through to take any asset from a person that passed to their beneficiaries. And it is different in each state, but the three primary steps that every probate goes through is number one, you have to file the will with the court. And your executor does that. It's the person you name to handle everything. Your executor has to go to a courthouse and present it to the court. And then next, that executor has to provide notice to all interested parties and to the general public. And then finally, the third step is you have to account for all of the assets for the person who died. So that process in itself is not complicated, but you open yourself up to all sorts of unnecessary risks, such as will contests or creditor claims. And also, as you mentioned, this is a very public process. So if you don't want your personal financial statement to be public knowledge, then you really want to avoid probate. So, and if you think of this from the perspective of your loved ones that you leave behind, probate is just this unnecessary stressor that you can eliminate it relatively easy with a good estate plan. So why wouldn't you do so?
So if we want to avoid probate, trusts are often a frequently used solution. Can you break down the most commonly used trusts?
Sure. That's a great question. Well, we often use something called a revocable trust to avoid probate. And first, it's important to understand that probate only applies to assets that are in an individual's name. So anytime you transfer assets out of an individual name, you can remove assets from their probate estate. And the easiest way to do that without losing any control over the assets is by creating a revocable trust. A trust, that's when you create an entity and you transfer assets to a third party. And that third party is called a trustee. And the trustee manages the assets for the benefit of another. And you can think of a trustee just like an agent under a power of attorney or an executor under the will. They're the person in charge of carrying out your wishes. The interesting thing about a revocable trust is that although you don't technically own the assets you put in your trust, for probate purposes, you can name yourself as a trustee, and then you still retain total control over all the assets. So for this purpose, revocable trusts are good for avoiding probate because you still control and benefit from those assets, but those assets are still includable in your taxable estate, and revocable trusts do nothing in terms of creditor protection or estate tax savings. If you were looking for more asset protection or estate tax savings, you'd have to create an irrevocable trust. And when you create an irrevocable trust, you select the terms of the trust, you name a trustee to carry out those terms, but after that, you have no say in what happens to those assets. But an irrevocable trust, that effectively removes assets from your control. And when you do that, you have to name somebody else to be the beneficiary. And sometimes people assume that trusts are just for the ultra wealthy, but that's just not true. Trusts can be a wonderful way to pass assets to your beneficiaries because they offer asset protection. They can isolate those assets from any kind of litigation. So if you had a beneficiary that was in an accident and was sued, those assets would not be subject to that litigation. A creditor couldn't get those assets. And also, if you had a beneficiary who was going through a divorce, any assets that your beneficiary holds in a trust is not subject to division on divorce. So if all you're trying to do is avoid probate, a revocable trust is a great tool. But if you wanted to create some asset protection benefits, then an irrevocable trust might be something that you're looking for.
Yeah, absolutely. And I mean, we're certainly not going to dive into it today, but that really comes into play if you're very charitably inclined. If you've got, previous spouse, children from a previous marriage, new spouse. Also, I think, if you have someone with special needs in your family. So all important things to consider when crafting your estate plan with a lawyer. Mm-hmm. So to move on, there are also other ways to protect assets from probate just by titling them differently. Right. Or using beneficiary designations depending on the type of asset. So can you explain how accounts can be titled or beneficiaries listed to pass directly to another person?
Sure, absolutely. Not everyone needs a revocable trust to avoid probate, as you're pointing out. Remember, probate only applies to assets held in your sole name. So any kind of asset that you have jointly held, that's going to pass directly to your surviving joint owner. That skips probate entirely. And then also any asset that you have a beneficiary designation, and that's where you name a person that's getting the assets when you pass. And that's anything like a payable on death account or a life insurance policy or an IRA with a named beneficiary. None of those assets are subject to probate. They go straight to the beneficiaries. For instance, I don't have or need a revocable trust because everything I own jointly with my husband, and he's the beneficiary on my 401k and insurance policy. So you're right. You don't absolutely need a revocable trust to avoid probate. Sometimes just the way you title your assets can do that.
So are these documents that we create, whether it's, a revocable trust or a will or a power of attorney, are they a one-time thing or should they be reviewed often? If so, how often? And what are some of the common triggers that would come up throughout life that would, suggest it's a good time to review them?
Great. That's another great question. So your estate plan, as you're alluding to, it should evolve throughout your life. Anytime you have a major life event, such as the death of a loved one, a marriage, a birth of a child, you really do need to revisit your plan. So barring any significant life event, I'd suggest sitting down with your estate planning attorney maybe every 3 to 5 years to update those documents. And what's so nice about working with you, Alissa, and clients of the CPA firm is that with you all, it's an ongoing discussion because you're meeting with your clients at least annually. And you know when something comes up in their life and you're constantly talking about these plans and any kind of life changes. So it's nice to know that you're out there helping clients identify when they do need a total overhaul of their estate plan.
Absolutely. And so lastly, what are some common estate planning mistakes that you see?
Well, I think the most common estate planning mistake I see, it's not really with the estate plan itself, but it's the communication of the plan. I think it's critical that you have discussions with your family regarding your plan during your life. Most legal documents will effectively name the people to carry out your plan, but it's a kindness to have that conversation with your family ahead of time to avoid any conflict when you're not around to explain the decisions that you made. So, and I think it's especially important in blended families where there are those competing interests. So you don't really create an estate plan for yourself. You're doing it for your family. And it's to make things easier on your loved ones at what might be the most stressful and overwhelming time of their lives. So I think that's why it's so important that you sit down with your family and you review your estate plan with them. So there's no surprises or any unnecessary stress.
I would agree with that. And also with your financial advisor, your CPA, these are all people that should be in partnership working together with your estate attorney so that everybody is aware and can kind of create your full financial picture for you. Laura, thank you so much for joining me today. You've provided us with such a wealth of great information. Really appreciate it. And if any of our viewers have questions, please reach out to us at sdwealthmanagement@schneiderdowns.com.
Thanks so much, Alissa.